So, we're here today to discuss the situation between our two clients. The story, as we understand it, is that our client, Al, entered into a contract with the Bitners after submitting a bid based on a drawing that your client completed involving the remodeling of their home. And ultimately, as time progressed, the actual renovations that took place differed somewhat from your drawing, but also, in some respects, did use your drawings. And as time went on, the relationship, I would say, between our client and the Bitners has become more strained. There were discussions regarding some of the additions to the remodel and changes from the drawing between our client and the Bitners, which are the subject of a disagreement. And now we're at an issue here where we filed the lawsuit because our clients are hoping to recover the money that we feel we're owed by the Bitners as a result of the extra work we've done. And your client is in the suit as a result of the counterclaims the Bitners filed against us, one of which being the fact that they've alleged that we were negligent in our designation of certain materials. Those materials also being reflected in your client's drawing with regard to the roofing and the flooring, negligent in regard to the fact that the materials weren't available. And so because new roofing and flooring had to be acquired, they're essentially stipulating we were negligent, and then by extension, we're saying that if we were negligent in that your client shares some share or burden of the responsibility in terms of having also done the drawings. Do you understand the situation to be about that, or?
Sure. I think my client was very perplexed when she was brought into the suit because as a designer, kind of her role ends once she hands over the design to her clients, which were the Bitners. As far as the materials are concerned, it's not uncommon for materials to go out of stock or for there to be a shortage, and for the builder then to go ahead and make the adjustments necessary in accordance with what the client, the Bitners, wanted. So my client is very confused as to why she was even brought in the first place. And, she feels that she has really no role in kind of any negligence of choosing the materials. She just went off of what was existing on the house, which is common practice in the design world, is to just kind of try to match whatever is in the house. And then it's then the builder's responsibility to go ahead and choose the materials, as required for the project.
Going after that, I know you mentioned that being standard, you make the drawings, and then after that, it's kind of the responsibility of, the homeowner and then the contractor to determine what materials are required. So what was, your client's level of involvement from the moment she handed over the drawings to kind of, throughout the process of building the home?
As far as her understanding of her contract with the Bitners was involved, the rate that she was paid was for the drawings alone. And that was all really that the Bitners wanted from her.
Okay. What was the rate that she was paid at?
I believe the Bitners paid her something along the lines of $5,250.
And has she been paid that value?
I believe she has. Yes.
Okay.
So you mentioned that it's typical practice for designers to pick materials, and they may happen to go out of stock in the time between it being built or not, and that would be typical after handing off the drawings to be done. One of the issues with the roof in particular, and the reason that we were not able to use the material the roofing was because it was out of code. The roof itself was legal and didn't comply with the city ordinances. So I guess my question would be something along the lines of, would you say it's very typical for your client to look at the roof as it is existing and maybe confer with them about the current material, in regards to the fact that if the current material wasn't even usable at the time it was up, perhaps that's, an issue with the designs as well. Not per se that either of our clients were negligent. I just want to put out there the basis for us bringing your client into the suit is that if we were negligent, and I know one of their sticking points is the roof and the flooring, and designating the materials we did and having to change them, I think perhaps the designs as well would be implicated. Now, I would not say that either of us were negligent as it stands. I think obviously we can test that, and if we went to court, we would fight against that. I just think it's important that we're saying if we are held negligent, we feel that because the designs were drawn also at the time of illegal material being used on the roof, that there would probably be a negligence claim that, we would split some responsibility on.
I believe that as a designer, my client's role is not necessarily to check to make sure everything is up to code. That's why the builder generally obtains the permits from the city for the work that they're going to do. So it really wasn't her responsibility to ensure that materials or anything was up to code.
I think you're completely right. Like, there's a lot of things like, the HVAC, the electrical, like flooring, roofing. Like, there was really no way, the designer could know that these things were defective or didn't make like city or industry standards. So then, from your perspective, like, do you think that these were things that can commonly be revealed later on as you begin to start working on a house?
Sure, from my client's experience, kind of designing plans for homes, that is generally what happens. The designer makes the plans and then hands them off to their client, who can then obtain bids from contractors and builders. And if the builder has any questions as to, whether something is code-worthy, they would then enter that into their contract with the client, so that they can make the appropriate rate adjustments as necessary.
What is your client's relationship like with the Bitners, and then how did the Bitners go about contracting with Lily?
So the Bitners and my client are acquaintances, they're personal acquaintances. They had an oral contract with the Bitners to draw plans for the renovation of the house.
Okay, and what's your client's current stance on the renovations that were done? Like, I know it took a little bit longer for the renovations and the work to be done because it turned out to be so much more work than what we were seeing eye to eye in the contract. But what is your client's perspective on the timeline, the new different flooring that was used and the extra work that was done?
My client, as far as she's concerned, she was brought into a meeting kind of earlier on with your client and as well as the Bitners, and I believe she was kind of she felt that she was being coerced into taking sides, and that's not what she's interested in.
Okay.
She's interested in kind of the facts as they are, and she wants to stay out of this lawsuit as much as possible. She doesn't believe that she should have any responsibility for any of the occurrences that happened. But that being said, my client's testimony could be very swaying to a jury or a judge at trial. So I think that's something that we should keep in mind. But again, she doesn't want to get into, getting into taking sides on this issue because she is an acquaintance of the Bitners.
I think your client and our client would probably agree litigation is probably not the most effective way to solve this issue. I think more than likely it'd be preferential to everyone, including the Bitners, if we could resolve this without having to go to court. And so I understand your client's primary interest is probably just getting out of the lawsuit. And so I think that's something we can work with your client on. I'd also ask, your litigation tends to create tension amongst the parties. Obviously, our client and the Bitners certainly don't have the sort of jovial relationship they did at the start of the process. Your client, I understand, is a personal acquaintance with the Bitners. Are you and the Bitners still on relatively good terms, or are your client and the Bitners been sort of strained by the constraints of the litigation?
I believe they're still on relatively good terms. I don't see why there would be, as much animosity between them, given that, the Bitners were not the ones who brought my client into the suit in the first place. So I think their relationship as it stands is okay.
Okay, and I would also say, just to clarify, I agree that we did bring your client into the lawsuit. I would also just frame it as not per se that we would have done it any other way, but the way that the claim is styled, that the Bitners filed against our client, is that it's a negligent designation of the materials. And so I think ultimately, when our client submitted the bid and then, obviously is being held to that bid and the contract that we later signed to use those materials, we did rely on your client's drawing at that time. And it's not per se that we think your client was wrong to have done that. It's just that the way the claim is styled, I feel our client didn't have much choice but to also potentially assign responsibility if there is any. Not that a court per se would agree that either of us have responsibility for negligence, but for it to be a misdesignation, it would be hard for it to only be our client's fault because he's really making the designation based on drawings submitted to encourage the bid, and any changes later really wouldn't be a misdesignation of material so much as a change they would be arguing about.
Okay. And so I guess because it's not in either of our interests to like go to litigation, we're kind of all trying to come together and come up with a settlement agreement. As of right now, there's a current balance that the Bitners owe Atrium, roughly around $100,000, and so it's really in our interest for us to, not have to go to court at all. We would like to alleviate all the litigation costs and all the like financial troubles and emotional troubles that from your client as well. And so, what are your thoughts on us like coming to some kind of agreement so that way we wouldn't have to go to trial and we could settle this?
Sure. My client definitely would like to avoid trial, as would probably all of our clients. That being said, she does not believe that the suit against her has any ground. So she really is not only looking to kind of get out of this lawsuit, but to recoup the attorney's fees as they've added up as a result of her being brought in on kind of a groundless suit.
Okay. Is there some kind of timeline that your client is functioning on? I know you mentioned she would like to recover some monetary damages. Is there like a timeline that she would want those by, or
not necessarily? No.
Okay.
When you're talking about your monetary damages and the attorney's fees that have been racked up so far, is there a figure that your client has in mind that they're hoping to recoup towards those, or what do the attorney's fees look like as of right now?
Right now, I believe I'll have to go back and check with my accounting, but I believe it's around $1,000 that have been put into this case. So that's what she's looking to recover.
Okay. And another question I guess I would ask is, at the time that she drew the plans, I know she's a designer. She's designated on the contract between the Bitners and I as the architect. Is she an architect at this point in time, or is she still a designer?
She is a designer. She was never an architect, and we're not sure why your client kind of drew up the contract naming her as an architect, but to my knowledge, she was not involved in the writing and drawing up of that particular contract, and she had really no role in what her designation was on paper, but she is a designer, not an architect.
Okay. And so your client ultimately, if I could sum up her interests, would be first to get out of the lawsuit and to have as little involvement with it as possible, and second to recoup the attorney's fees that she's had to expend up until this point.
That's correct.
And are there any other sort of interests that your client has in this settlement agreement?
No, those are her primary interests.
Has your client so far talked to the Bitners regarding getting out of the lawsuit and a settlement agreement?
We haven't yet, but we are contemplating kind of meeting up with the other side's attorneys to talk about where we are with this suit.
Okay. And then there were some conversations throughout this contracting that happened from signing the contract up until the very end. I know in late June, Benny and Al, they had a face-to-face conversation where Benny Bitner expressed how he's struggling to pay some of the balances. Were you there for that conversation?
No, my client was not.
Your client was not present.
I don't believe she was.
And then also at the very end, all of Benny, your client, and then also Al, we were all together, and the discussion came up about the remaining balance where Benny Bitner was really upset, and he felt like the work was just taking too long and it was stretched out, and he felt really deceived. Was your client there for that conversation?
I will have to double check with her, but I know that she was present for a meeting between Benny Bitner and your client. I'm not sure if that was the exact meeting that she was referring to.
Okay.
So I'd like to ask you a question. I know, obviously, your client being a friend of the Bitners and, frankly, having no interest in the suit to whatever degree possible, doesn't want to be involved in finger-pointing and such. I mean, obviously, your client potentially has, observed the relationship between the Bitners and ourselves, and like you said, could have very valuable testimony. I don't know that in order to reach an agreement, we're expecting you to, go to court, but it may be helpful in assisting us, reach an agreement with the Bitners that will allow us to let your client out of the suit and to put all this behind us. If your client is willing, and not, to say anything that didn't happen, but if your client did witness certain conversations, or if your client did hear things, and, we've had certain reports from our client regarding things your client may have heard, if she could substantiate any of those, that likely would be helpful to us in structuring an agreement with the Bitners, and then obviously letting your client off the hook.
Sure. If you want to send over or just verbally kind of reiterate what it is that your client has informed you about my client's kind of involvement, I would be happy to bring that back to her and see if she'd be willing to substantiate those claims.
Sure. And I can tell you this much. One claim in particular that our client has reported that your client was present for the conversation on was they were discussing towards the end of the remodeling process the sort of state of the entire project, and Benny Bitner was at least somewhat upset at the increased cost, and our client asked her client, understanding that she may be conflicted and not want to comment on it, what she thought of the process, and she our client reports was willing to agree with him and say that she really did think a lot of extra work had been done, particularly in regards to where the drawing started, and that it even could have cost more than it did. Not that our client was sort of pulling the wool over Mr. Bitner's eyes and trying to get him to pay for a bunch of stuff where there was no value. I know that in particular is a conversation that obviously has a degree of importance to us, and that our client, would be much more amenable to helping get everything settled with if it could be substantiated.
Okay, I'll bring that back to her and see what her recollection of that conversation is, and I can let you know what she says.
Okay.
So just to kind of go back, like the first interest of your client is to not be a part of the litigation at all and to be a part of the settlement agreement, and then second interest would be attorney's fees.
That's correct.
Okay, and so if we're able to come to an agreement today on being able to pay a certain dollar value to your client, is that something she'd be willing to sign off and release?
I believe so, depending on what the terms of that agreement are. But again, because it is the Bitners bringing this suit against you and ultimately, or your client, and ultimately against my client, that agreement would really have to be kind of regardless of what happens between y'all settlement agreement with the Bitners, that she would be, cut out of the suit.
Okay, that makes sense. So regardless of what would happen between like Atrium and Bitner, like she just doesn't want to be a part of the suit at all.
That's correct.
Okay, that makes sense. Are there any other interests of your client that you could maybe speak to?
I think what we've covered are her primary interests.
Okay.
So if we want to take a break now, I can go ahead and contact her and see what she has to say about that conversation between the Bitners and Atrium.
Great. Yeah,
Great.
Let's do that.
So I spoke with my client, and she is not willing to corroborate any statements or give you kind of any substantiated conversations unless your client is willing to drop her from the lawsuit completely and also pay her attorney's fees.
Before we could discuss what it is we could agree to in terms of letting your client out of the suit and any compensation, we'd have to at first discuss what it is that your client is prepared to corroborate.
So she recalls from that conversation that she believed that the square footage per foot square footage charge was appropriate and reasonable for the higher end homes in Austin, and that your client did do a good job with the renovations.
So what it really sounds like is that your client is affirming the fact that Atrium did not overcharge or take too long, and the renovations that were done were to market standards.
Well, my client also does recall stating that she believes that Atrium may have contributed to the delay.
Okay.
But
do you have any more information on things that Atrium might have done to cause those delays?
That's the extent of what she's told me.
Okay.
In other words, though, your client would be comfortable confirming that the market value of the home is appropriate for the renovation. So essentially, the renovations were well worth the value that the bidders would be paying.
She's not really aware of what the market value of the home is right now, but she does know that the price charged for the renovation per square foot was reasonable, and that your client did do a good job with the renovation. So.
Okay. Well, we're really excited to come to an agreement, at least today, with you. And it's so, given the interest being that you would like to get out of the suit and we want to cover attorney's fees, we could maybe come up with something conditional.
I don't think we could let your client out of the suit totally right now. I understand that your client wants to get out, but prior to discussing things with the Bitners, it's obvious that your client's testimony could be important, and I don't think we could be comfortable, getting you out and losing that testimony potentially if the settlement with the Bitners becomes not possible. That said, I think potentially your client may have told you about this as well. My client has informed us that there are rumors that the Bitners' marriage may be in trouble. And so that, coupled with the idea that your client may corroborate some of these things, will put the Bitners under considerable pressure to settle. And so I think it's very likely we can settle with them. So we could agree something tentative with you, but I don't think we would be able to let your client out of the suit totally right now.
Okay, so what would kind of the language of that tentative agreement look like for you? Because my client needs substantial
We would make the language of it very strong that if we were to settle something with the Bitners tomorrow, then we would release, all liability and all any kind of cause of action in the future against your client, and we would also be sure to cover the attorney's fees. Again, that's something we don't know because we still have to go meet with the Bitners, but given all the circumstances and information, it's within all of our interests to settle, and we really do appreciate you cooperating with us and your client cooperating with us too. And so we would just make sure the language is that, if we do settle tomorrow, then it's within our interest to release her from the suit and cover attorney's fees.
Okay, so the language would be kind of regardless of the outcome. If a settlement is reached, regardless of the outcome of that settlement agreement, your client will cover all of the costs or settlement amount that is due from the Bitners, and you will cover my client's attorney's fees. Is that correct?
What I would say we would be prepared to say today is if your client would give us the authority to go into our settlement negotiations with the Bitners tomorrow and put out the fact that you were willing to corroborate that you think the renovations were appropriate for the cost, and that that you think that the client charged a fair rate, we would be willing to say that we would let you out of the suit, and we would be willing to find a way to cover your attorney's fees. The only thing I would say is this: pending a settlement agreement, yes. Assuming the Bitners and our client settles, we would be prepared to offer you that, but it wouldn't be a total release in terms of if we were unable to settle tomorrow, we couldn't let you out. So we'd have to, if we come up with a settlement, regardless of what the dollar figure is, we could deal with that, and we would be fine with allowing your client indefinitely out of the suit. But if the Bitner negotiation, for whatever reason, didn't pan out, we wouldn't want to give you a total release, like right now, as soon as you leave the room, you'll never have to worry about the suit again. That said, the Bitners potentially will be divorced, and obviously Benny is the owner of the home, and that would put Peggy under considerable pressure to want to settle this because she could be on the hook for liability that stems from a house she doesn't even own. I think the Bitners will be in a position with your client backing us and with their potential marital issues where they will need to settle. And as long as they settle, we have no problem getting your client out of the suit. We don't want to go after your client. We just want to get our client what he's owed.
Okay, I understand. So, as is, my client will not be willing to provide you any kind of written statement, but I do have her verbal agreement that she will attest to the things that she said regarding the market value of the renovations and all of that. So you can take that to your negotiation with the Bitner's attorney, and you can let them know that my client has substantiated what was said in that conversation, and this is contingent upon the verbal agreement between us that if you reach a settlement agreement with the Bitners, that you will not hold my client liable for anything and that you will pay her $1,000 attorney's fees. Is that correct?
We can't completely agree to the $1,000 of attorney's fees, but I think that because we have no idea of what's going to go on tomorrow, but I think if we were to come to an agreement and settle with the Bitners, then there's a very high possibility that we could definitely get you the $1,000 in attorney's fees.
I think one other important thing is we want to make the settlement agreement happen. And again, I think the odds are very high of us being able to do that with your client's support. I think, being that we want to help your client get out of the suit and that's your interest too, it would be important that we come to some sort of tentative agreement that there wouldn't be any side negotiation between your client and the Bitners, at least until we've had our first chance to negotiate with them. I think we will be able to come to an agreement, but I think obviously if your client were to, have any other negotiations or dealings with the Bitner, that would probably impair the ability of us to make this a quick and efficient solution. So if we would also ask that you would refrain from negotiating with the Bitners until after we've had a shot, after which we believe it'll be settled and we won't have to worry about it.
Okay, my client can agree to, not communicating or have any, side negotiations with the Bitners, but again, my client does need her attorney's fees covered. So we just need some kind of assurance from your side that that will be taken care of, contingent upon, regardless of what kind of agreement you reach with the Bitners, if a settlement agreement is reached.
Okay. If a settlement agreement is reached and the Bitners pay us a sum of money, so assuming the settlements don't fall apart and force us to go to trial, I think we would be prepared to say that we will structure the settlement agreement such that your client will not have to worry about the litigation going forward, and $1,000 attorney's fees will be doable, provided we reach a settlement agreement. Obviously, if things fall apart and we can't reach anything, we wouldn't be able to give you any of these guarantees. So as long as it's understood that you're committing to allowing us to at least tell the Bitners that you support us and you're not going to contradict that until we've negotiated with them, that would be fine. I mean, you don't have to give us a signed agreement that says we're going to back Atrium, but we need to be able to go in there and tell them, hey, look, we spoke to your attorney and they've authorized us to tell you that they're prepared to corroborate this testimony so that we come in a position of strength. Again, you won't be bound to it if the settlement agreement falls apart. Then I understand your client may want to negotiate with the Bitners, but if you refrain until we have and you promise us that we can at least tell them that, we should be able to make this work.
Yeah. And so, I mean, I know you still want the attorney's fees regardless of what happens tomorrow. It's just that, unfortunately, we can't completely promise that. But I think knowing that, there's not going to be any side settlements tomorrow up until we talk to the Bitners tomorrow, what we could do is we could touch base again after we have our conversation with the Bitners, and hopefully it's good news and we're able to provide the $1,000 in attorney's fees. But if we don't come to the agreement, then we could speak again with you and we could try to work something out between all of us.
Okay, so what I'm hearing is that if you reach an agreement with the Bitners, that you will release my client from any liability and you will pay the attorney's fees. Is that correct? If you reach an agreement with the Bitners tomorrow.
Yes.
Okay, that sounds great.
Okay, great.
Right.
So that works. We'll get back to you after that, but I think we shouldn't have a problem reaching a settlement.
Sounds great.
So thanks for meeting with us. We're sorry that we had to call you back again. I know we were hoping to wait until after the Bitner negotiation.
Mm-hmm.
But just before we negotiate with the Bitners, which we're getting ready to do here pretty shortly, we wanted to kind of shore up our position with you. And we were thinking about your testimony, and we think it could be beneficial to get some of your client's background so we could really hammer in what sort of expertise that testimony brings to the table.
Sure.
What about your client's education?
So my client graduated from the UT School of Architecture. Although she is not a licensed architect, she worked primarily as a designer and continues to work as a designer. So she's not an architect, just so we get that clear.
So after she graduated from UT, what are some of the different projects that she worked on?
So she actually worked at a large local architecture firm for a decade, I think she was at that particular firm for 7 years, where she worked on various different projects. She worked on both commercial and residential, and some of these projects were very high budget, multi-million-dollar projects. So she does have extensive experience kind of in, designing plans for these types of facilities and homes.
You mentioned that she did both commercial and residential work. Do you know sort of what the split was between those? Is it more residential than commercial, or is it about the same?
I believe it was about half, 50% commercial, 50% residential. So she does have some significant experience kind of in both areas.
And what is your client doing at the moment?
So she's working, she's currently self-employed. She runs her own business. So she does design plans for, mostly residential homes now. Most of her business kind of comes in through word of mouth. And she's, very careful not to describe herself as an architect because she is not licensed as one. She kind of markets herself as a designer of homes.
And just to clarify, is the work she's been doing with the big firm and the work she's doing now, has it been in the Austin area the entire time?
I believe so, yes. When she was at the large firm, that was local to Austin, so most of their projects were in Austin.
And you described some of the work, like the residential work that she did at the large firm and the work that she's doing right now to be pretty similar?
I believe so. She's kind of using what she's gained, the knowledge that she's gained from her prior work experience, and using it for her current clients.
Okay.
I just also wanted to bring up one thing. I know we discussed that my client would be willing to substantiate the conversation that happened between herself and your client and the Benny Bitners. I just wanted to make sure that when you represent that, our client is willing to support that statement. I just don't want it to come across as we're, taking your side and attacking her. So I just wanted to make sure that we could kind of shore up the language to make my client, appear neutral and not like she's trying to attack the Bitners.
We already sort of have a contentious situation with the Bitners, and we recognize your client has a relationship with them outside of business. So we'll be sure not to make it look like you're pointing fingers or taking sides. We'll just simply say that, like, if it were to come up and we were to use it that way, that you recall that a certain conversation had, but not that you were, indicating that you wanted to back us at trial or anything.
Okay.
Yeah, our interest is to really keep all of our relationships, all three of us, to be as positive as possible, and it's just in our interest for all of us to be happy out of the settlement. So we'll definitely not do any kind of finger pointing or using any kind of language. But yeah.
Okay, that sounds great.
Great.
Well, thanks. It's been super helpful. We just wanted to make sure we had a more extensive picture of your client's background, so when we were discussing what that opinion meant, we would have some way to find it.
No problem.
Well, thank you so much, and we'll
you.
be staying in touch with you after our conversation with the Bitners.
Sounds great. Thanks.
Taking the time out to meet us today. We're really interested in coming together and coming up with a solid settlement between both Atriums and the Bitners that we can both agree on and be happy with. And so I wanted to start this settlement off by just going through a brief statement of the facts, our version of the story, our client's version of the story, and get some of your perspective on that. So our understanding is that the Bitners hired Lily Cochran, a designer, to come up with some sketches, and then our client, the Atriums, the contracting company, they submitted a bid, and they were selected by Benny and Peggy Bitner to do some renovations and construction on the home. The work began on August 20th, and it was scheduled to be completed on June 19th, and it was actually completed on July 18th and 19th. Starting around May-June, the relationship started to strain out, and bills weren't being paid. And so we had an attorney draft a demand letter for $98,346, and that was not including the builder's fee, but it's in our interest in the settlement to come up with a total of about $101,000 from the settlement. And throughout the timeline of the contract and the construction that was being done on the house, there were some discrepancies on what was on the drawing and the work that was actually being completed. And so this is kind of where we're at on what's been going on in the events, and we'd really be interested in hearing your side.
Yeah, thank you guys for meeting with me as well. This has obviously been quite an emotional experience for the Bitners, but they are looking forward to getting this settled and getting this taken care of so that we don't have to take this on to trial. Regarding the relationship and hiring Atrium for the repairs and renovations, as you are aware of the original bid with all of the outline repairs for the addition with each price, and the contract regarding potential increase of 10%, either higher or lower for the final amount. The Bitners were, okay with this, but as time went on, there were certain things, as I have laid out in my response to your demand letter, regarding repairs that were simply just not what the Bitners had anticipated from the beginning. And some of that, excuse me one second, some of that, included differences in materials that required the Bitners to replace their entire roof, or differences in flooring that it's my client's position that your client was aware of that wound up increasing the cost for far more than the Bitners had originally anticipated. So that would be just some of them would be the electrical work, the HVAC, the flooring, the roofing, and the drywall.
Okay.
And all of those things, there were just many changes from the original bid that the Bitners just they seemed blindsided by.
Right.
Changes in material and things that a professional in Atrium's position we expected to have anticipated. So, and I had laid out as well in the response to the demand letter about our DTPA claim, which my client believes that your client's actions fall under these claims. But again, this has just caused so much stress for the Bitners. As you know, Mrs. Bitner was pregnant during this, and it has caused just a real strain on their relationship. And at the end of the day, they would just like to be able to, get this set aside and wrap it up, and regardless of what happened, just, do something to get this straightened out.
Thank you so much for sharing your side and your perspective, and we're really sorry for what the Bitners have been going through. We know they're expecting a new baby, but so on the discrepancy of what was expected on the about $327,000 estimate and then the final bill, what do you know what the difference was?
I'm sorry, can you clarify?
Basically, the estimate was for $327,000, and there was a discrepancy as there was a lot more, substantially more work being done on the HVAC, the flooring, the roofing. Would you happen to have a number and a difference between the estimate and then the final cost, the final bill?
Well, the final invoice includes an amount you're asking for $100,000.
So that's exceeding the $327,000.
Yeah.
So $327,000 is the balance that's been paid to our client.
Yes.
Okay.
Yeah, I'd just like to ask, I guess, a couple of questions.
Sure.
I understand, your client's position currently is we initiated the suit following the demand letter, and we just, reached out and we're hoping to acquire in this lawsuit the balance on that account. And initially we had placed it for the $98,000, knocking off $3,000 the builder's fee. We do want to clarify in the petition we were saying we'd like to, start the negotiation with the builder's fee back in place. So at 101, like Gia said. And you guys' position is essentially that we are also in breach of contract. You're alleging that we had a negligent misrepresentation in terms of designating the materials and the DTPA claim. And your letter in response to sort of the suit and where we stand in settlement indicated that it was your position right now that we would sign an agreement sort of waiving our right to the account and we would put it behind us. I mean, obviously we both have opinions of both of our cases, and I think we both agree, settlement would be probably a very efficient resolution, and we can probably agree it would be nice to not need to go to trial. Is it still your position that you would just like us to give you a written agreement, forfeiting our rights to the account, or is there negotiation to be had?
Well, the Bitners are of the position that they should not have to pay for any of this additional costs, because $327,000 initially was a lot for all these repairs, and they contemplated other options as well,
right,
besides just repairing and putting additions to the house. Like, they contemplated purchasing a new house, but they made this decision based on your client's representations of materials to be used excuse me, how to get the job, like how long it would take to get the job done. And I think that level of trust between them really, I think my client feels that was, harmed a little bit by all of these additional expenses. As I said, I think they feel a little bit blindsided. So while it is, my client's position that they shouldn't have to pay any of this additional $100,000, we are prepared to pursue the DTPA claim specifically, because I think that we have a really good position on that. But there might be something that we could do. Is there something that you are willing to, I guess, change from the initial $100,000 that you're asking? You said you're asking for the builder's fee of $3,000 to be put back in addition to that for your initial offer.
So I think as of right now, the builder hasn't been paid, and on top of that, he also owes a big balance to a lot of the subcontractors and everybody he bought materials from. So I think it might be a good idea for us to explore some of the discrepancies that both of our clients had in terms of what was on the drawing and then the substantial work that was done, like kind of how you mentioned the HVAC, the flooring, and the roofing. I think if we can get a better understanding on the facts and the versions of the story, it might allow us to move a little bit more on coming to an agreement in other places. And so with that being said, I'm interested on actually hearing the two different sides of the story on the HVAC, the flooring, and the roofing, because these are things that it's very common in construction contracts and specifically designs where a bid is made and you submit a bid, but there's not everything, like you can't see everything to eye on a piece of paper. So a lot of these changes were made like after, demolishing, and there was over actually 1,500 square feet of new construction and 500 square feet of modified space. So we're talking about 2,000 square foot. So there's a lot to be covered here. And so I'd really be interested in hearing where really we went south, on some of the improvements.
Right. I think that the Bitner's main position on that, as I've kind of alluded to in our response to your demand letter, was, especially with the electrical and the HVAC, while I understand that changes can come up that you might not see in initial drawings or after demolition, it's the Bitner's position that this is something that was still easily, ascertainable to your client, just as, professionals in the industry and working with the subcontractors and, knowing to your level of expertise, the types of materials used, that such a discrepancy in the change, while we understand that some changes, is to be expected, I think that this was something that was more than that, which would make us question whether or not, Atrium knew about this beforehand and failed.
Why didn't at any point, like, they demolished, the HVAC happened, I mean, there was several changes being done, the plans showed only one recessed fixture, there were 4, I mean, these were all just hard estimates, like, that are subject to change when you're doing that much construction. At any point, if your client was concerned about the strong rise in the cost, like, why didn't he just terminate the contract?
I think part of the reason that the Bitners didn't do that, and that some of the extra work was, was not specifically said, like specifically terminated the contract. At the end of the day, we think Atrium, guaranteed no more than a 10% increase of that
That
bid.
was a guarantee.
Would you mind giving us just a second to talk over sort of your side, and then we'll get back with you on that?
Absolutely.
So you mentioned that your client feels like there were a lot of misrepresentations that happened from the beginning of the designs to the end of the contract being executed. Can you kind of go into some specifics on the grounds that your client and you have for the DTPA claim?
Sure, yeah. So as written in my response to the letter, we believe that we would be able to pursue a claim under the DTPA, specifically Section 17.46 A, B, and then 2, 3, 7, 9, and 24. And basically, I'm not sure if you're super familiar with the DTPA, but basically it goes into detail about just certain deceptive trade practices that are unlawful in Texas. So, the first one we believe is really representing that goods and services are part of a particular standard, quality, or grade. There was definitely an issue with this with different materials that were used for the flooring and the roofing.
Right.
The roofing specifically caused the Bitners, to have to redo the whole roof.
Okay.
So that's one that we really feel is one of the main ones. Additionally, sections 2 and 3, causing confusion or misunderstanding as to source, sponsorship, approval, or certification for goods and services, or affiliation, connection, and association. Basically, the same thing, certification of the goods and services used for these products.
So it seems like there was a lot of discrepancy on the types of materials that were used and the amount of work that was being done. First, going back to the roofing, are you aware that the roof that the Bitners originally had was not up to city code standard and it was completely not workable? So there was a requirement that the roof be redone, and throughout this entire conversation, our client did the best to inform the Bitners on the roof, and they worked together to come up with a decision and your client chose to redo the entire roof.
As far as the city code violation, our, Bitner's stance on that is that it was, flagged for a certain issue, and that had been talked about with the city inspector and Mr. Bitner, and it was cleared up from that point.
Okay.
So that's our position on the roofing.
So I guess in essence, it seems like the primary claim your client is concerned with is a DTPA claim, and as you know, the 3 elements necessary is to prove there's a consumer, which there's no dispute over. You're certainly a consumer, and then you need to establish some of the claims under 46B, and that the wrong flag produced the damages. I think it's important to also know the DTPA is meant to protect consumers from deceptive acts, and so a component of that is going to be intent. And so obviously both sides are going to have opinions and stances on how things go. It is our position right now that there are various things that we would point to help sort of clarify our client's intent. For example, the cost certainly exceeded what was initially put in the bid, although we would point to the contract and say it's clear that the cost is flagged as an estimate. It's not flagged as a total, and there's a 10% fluctuation period, but in no way would we represent the contract to say 10% is a guarantee or a maximum, because there's also the cost plus clause, which is what we think essentially has driven most of the changes, is that things came up and changes had to be made from the drawings, and the contract authorizes changes to be made, and the contract also authorizes it to be made either in terms of written changes or to oral agreements. And our client's position is that throughout the entire process, he negotiated with Benny and didn't make any changes that Benny hadn't authorized. For example, with the roof, I think one of the things with the DTPA claim there would be, the roof did have a city code violation, and regardless of whether maybe it was, squashed with the city inspector, it probably would be difficult to establish that our client, knew that the roof was defective and proceeded forward, because your client had knowledge about that, and it would be odd that your client didn't present to our client, hey, look, keep in mind we've had a problem with this roofing material, either to Lily Cochran when the design was initially made or to our client. Again, I don't want to sort of squabble over the differences. I just think there's going to be a lot of debate, particularly if we press this in court over intent, and there are several pieces in the contract that seem to authorize oral agreements to be made, and it's our client's position that negotiation went on both sides, that, he never went ahead with changes that weren't allowed. He gave your client options. Your client wasn't forced to do that. And I understand, I'm not saying that our client's right or that your client's right. They're both positions. But I'm not sure that the DTPA's position is sort of a slam dunk. So I think that, it's probably in both of our best interests to examine our positions and see what we're willing to do, because I think there will be numerous fact issues in pursuing a claim like that against us. And I think maybe we should examine that stance as not as strong as it might appear.
Okay. Thank you for going through all that. I definitely understand your position regarding intent. Our research also leads to damages under the DTPA, specifically with treble damages, and we feel like we have a good position with treble damages under the DTPA because not only is there an intentional requirement, but there's also a knowing level of requirement. So while the actions as you're describing them may not rise to the level of actual specific intent for reliance by Atrium regarding all of these changes that are different from the initial bid, we do feel pretty firm on our position that at the minimum, there was that Atrium had had knowledge of it, and that just requires acting with awareness that these things were going on. So the level of awareness, while I understand the gray area of the gray area of like the facts and circumstances of leading all the way up to a trial, we, even if there's not intent as far as the definition of intentional goes, we do feel that there was at least knowledge on the part of Atrium regarding
Do you believe
these
that
issues.
it's possible that whenever there are sketches made and whenever construction continues to go on, like changes can happen?
Yes, to a certain extent.
And what is your client's position on the verbal communications that were done between Benny Bitner and Al? For example, the information that we have is that our understanding is that, for example, when the HVAC room was completely demolished, there was a lot of new electrical work that came up out of that, and Benny even suggested putting in a wine cellar. And then even whenever they got to the roofing material, Benny had the chance to talk directly with Atrium's roof contractor, and they went into a long, lengthy discussion on the roof that Benny would like. And the very next day after Benny slept on it, he even had the opportunity to select the roof. And it really, in order to prevail under like a DTPA claim, there has to be some overstepping of authority, and our client had to do something that just was completely unauthorized and like misrepresented the work that he did or claimed to do. But I'm having some trouble understanding that because they were in communication about this the whole time.
Okay. While some of the information you said I'd have to, verify and discuss with my client, just a quick point. As far as like the wine cellar goes, that's not something that we're really, disputing a lot. Most of what we take issue with is what is the items in response to your demand letter. Okay. So we don't dispute that, the wine cellar may have been something that was an additional cost. Okay. But again, I think that the Bitner's position is that even if there were verbal communications about certain changes to be made, the end result was still not in line with those verbal communications.
I think it's also important to note that there's certainly a difference between intentional and knowing, and that I would agree that awareness is the level that you need to reach for knowing. I think it's also important to note that some of the issues we're talking about, such as Benny being okay with a wine cellar, and the fact that your client presumably was aware that there would potentially be an issue with using the same material for the roof, which he was aware of in the design plans before our client ever submitted a bid, are going to be factors that any jury or fact finder are going to consider when they ask themselves whether our client knew that he was, doing extravagant repairs or, allegedly extravagant repairs and really raising the price. It seems like our client's discussions where a wine cellar is authorized, discussions where your client, at least to our client's statement, indicated that him and his wife perhaps were not always on the same page in terms of cost priorities, and Benny being the homeowner, being willing to do a cost-plus arrangement and, authorizing changes on a continual basis seems to indicate to our client, and probably, makes it very debatable for a fact finder, that he's not aware that he's like levying extra costs or doing things that are outside the value that he wanted, because it seems like if you're willing to pay for some of these other things and you're agreeing when being presented with options, my client is not aware that he's, excessively charging you, and he certainly is not intentionally attempting to deceive you or pay more. Now, I'm not saying you need to concede these positions. I wouldn't ask you to do that. I just want to say I think it's important to keep all this in mind when we're considering the position. And I understand that, you're willing to work with us but I don't think we're quite in a position where we're willing to throw out a counter bid to our initial offers. I mean, we're willing to work with you and talk to you about what we can settle on, but I'm not sure we're willing to come out after having given you sort of what we're looking for and then bid against ourselves. Sort of need to get an idea as to where you're at in the willingness to move forward in a legitimate settlement.
Okay. Well, I mean, again, one example, just quick point before I go more into that,
Sure.
just going back to the awareness from Atrium of the materials used and the position of that not being, or not knowing that that was false. I think just one example of this would be the flooring specifically. You know, the contract, as we stated, called for the bamboo floors to match with the existing bamboo floors. And as a homeowner relying on an expertise of someone who's doing that, I think the falsity comes in of like not taking the responsibility to make sure that that material was available, which in turn had caused, reconstruction of the entire floor. That's just one example where you're saying that as verbal communications don't really lend to showing that Atrium was aware of the falsity, I think that our position would be that, in someone who has expertise in searching for the materials and stuff like that, we just think that it's kind of more on the part of y'all to
know these things. Yeah. So if I'm hearing you correctly, what you're saying is certain things like bamboo flooring, something as simple as being able to match flooring is something that our client, Atrium, should have done the due diligence and, went to a contractor and made sure he could find the match before putting that in a bid.
As just one example, and I think ultimately that the responsibility, regardless of drawings and how they may have changed and the subcontractors and the materials, ultimately the Bitners are in the position that the responsibility falls on Atrium, and that's where the issue comes in. But going back to what you were saying about, you're not willing to kind of re-offer a number, I guess. The Bitners are, we're willing to pay something to settle this, but I don't think that. I think that the amount in additional repairs, upwards of $100,000, is something that that's not. It's out of the range for them, I think.
See, at this point, like, we understand the tag of 100,000, 101,000 seems like a lot, but our builder's barely even getting paid. These are really, a lot of these costs are materials and to pay subcontractors. And so, it seems like the work that was done, there was a lot of more work done. And part of the premise of a DTPA claim is as well that there has to be a gross deviation from what the work was completed and the work that was expected. And so would you say that there's a gross deviation between the work completed and the value of it? Has another architecture or anyone come in and assess the value of all the work that the Atriums did over the year?
I personally am not aware of that information. If so, I'd have to talk to my client to see if there was other assessment of the work that had been done. As far as gross deviation, I believe the gross deviation mostly comes from the cost. And obviously materials and differences, having to repair entire flooring and roofing would be, I think, a gross deviation from the actual quality of the work, but additionally as well as cost.
Okay.
So those positions on the table, and potentially we'll revisit them and, offer up our different opinions on the new issues. What, upwards of 100,000 you've indicated is not something that the Bitners are willing to do, but what is something, or what is within the range of what the Bitners are willing to talk about, get the peace of mind of putting this behind them and ending this case?
Well, 10%, of the original estimated cost is $32,780.
Okay. So what you're asking for is the deviation that was expected to happen from the preliminary bid.
Yes.
Okay.
So just to confirm, to echo what you're saying $32,780 would be a number that the Bitners could potentially be comfortable paying as maybe a 10% deviation from the price, and that would be something they could settle for.
Yes, but could we take a quick break?
Yeah.
Oh,
Take a
sure.
break.
Okay, so to clarify, your last offer was 10%, and that would be a figure the Bitner still could be reasonable, and that figure is $32,780. I guess the first question we would have regarding that is that a sum we would be paid immediately upon settling, or how does that work?
Yeah, so that number, which is based off of, in the contract, the amount plus or minus the estimated cost, that would be foreseeable. As far as payment is concerned, there are kind of two options, I guess. There's an issue with, my client's financial situation with amount of cash available, and in the interest of getting this wrapped up, to an agreeable settlement, we would ask that the Atriums accept a promissory note for payment of the settlement amount on a specific day at demand, and that would be a legal promissory note.
So what that means is that, for example, if we have a promissory note that states 10 days from now to have an amount, then we could get that amount within 10 days.
Yeah, so I think the other in addition to that, which is kind of where our time frame comes from as far as the days, is that there's going to be a situation where the Bitners are refinancing their home, essentially, because of their financial situation. Okay. So in the event that you don't agree to a promissory note, we would it would be for about 45 days to secure that new refinance loan, which would make a 45-day window for payment. So regardless of whether you have the promissory note or refinancing, it would be a 45-day window.
I can ask a question in terms of how the promissory note functions. Do I understand correctly that a promissory note is a promise to pay a date, and if for whatever reason something came up, the enforcement mechanism would be to go to court?
Correct. It is enforceable as a legal contract.
Okay. And is that backed by a bank or anything, a promissory note?
Yes.
So at the end of the 45 days, a bank wouldn't just pay that amount out?
I'm sorry, can you repeat?
If we do a promissory note, and at the end of the 40 days, say the money is not paid by the Bitners, then would a bank come in and pay that, or is a bank not involved at all?
Oh, I believe it's just
the court order.
Yeah.
So one is
a
a court
promise for
order,
the Bitners to pay.
and then one would be a financing option.
Right. So with refinancing, they would get a new, interest rate and terms on their mortgage, just because of the financial situation as a result of this situation, and that would take 45 days to secure a new loan. So to have the amount for settlement, we would ask for a 45-day window.
I think I feel comfortable speaking for both of us and saying, not in a way that's offensive to your client, we would probably only be willing to consider the refinancing option. I mean, part of the benefit of the settlement agreement is not going to court on this matter, so I don't think we would feel comfortable going back to our client with a promissory note, which is essentially a promise to pay the cash, which could potentially have him go to court again, which is something he'd like to avoid. In terms of if he's going to settle, he'd like to just have it done and not have to worry about court anymore. So we could be potentially interested in the refinancing option. Given that the option is not going to be a lump sum payment and it's going to be refinancing, I think something we could be comfortable with doing, assuming a 45-day refinancing period, would be $80,000.
Okay. Can I actually take a quick break to look at some notes real quick?
Sure.
Okay. Thank you.
Yeah. Thank you for your patience while I reviewed some notes and looked at some numbers. Just looking at, again, the terms of the contract with, anticipated 10% addition to the estimated cost, and your offer of $80,000, we would ask that you accept $50,000.
Okay, so you'd ask us to accept $50,000, and I guess my question would be something along the lines of: is the $50,000 just a number that seems more comfortable, or is there any specific provision of the contract or fact that you would point to and sort of encourage us to consider that?
I think it's just a little bit more in the range of anticipated changes that aren't expressly in the terms of the contract. So the contract anticipates plus or minus 10% of the initial estimated cost. roughly 50,000 is 15%, so we're willing to work with that.
Originally, our client would have liked to have the money lump sum, and so given that now we're going to have to explore these other alternatives of a promissory note or financing, and we're selecting the financing option, which is also on a 45-day timeline, it's a little bit difficult for us to accept 50. Is there any possibility to move at all on the timeline of 45 days?
With the option of the refinancing, it will take 45 days to secure the loan, and it is my understanding from my client's information that their financial situation does not permit payment of a lump sum or other option at this point. Other than that, so whether it's the promissory note or the refinancing, the 45-day window is going to be necessary to get this paid.
Okay, that makes sense.
That said, I mean, I understand where you're coming from with 50,000. I get that your client feels that the 10% that is discussed in the contract was meant to be a guarantee. Obviously, our clients have different interpretations of that. Our client feels that the change orders and that provision following that is more indicative of the intent of the contract. So, pointing to that, we wouldn't be able to accept 50,000, considering that we're moving, as Dia said, away from a lump sum payment into a 45-day window for our client to wait. And because, again, our client sort of also has his interpretation of the contract as the change orders sort of being very indicative of the real intent of the contract. I mean, not that we're unwilling to continue working with you. I just think we can't accept 50,000.
Okay. I'm just reviewing some of the specific parts from our response to the demand letter and the bid, specifically different categories of work that was done, and just trying to assess my client's priorities and interests with those. So just looking at that based off of certain areas that they are willing to kind of wiggle a little bit on. Would you be willing to? Sorry, 1 second. Would you be willing to go in the 65?
I think we need to discuss that for just a second, and we'll sort of evaluate our client's position. If you don't mind giving us just a minute.
Yeah.
So thank you for your patience. We had the opportunity to talk it over with our client, and I think now would be a really great point for us to discuss Lily Cochran, as we did bring her into this lawsuit as a party. We really like Lily. We really like the work that she did, and we don't personally feel comfortable keeping her as a party in this suit, and it's really in our interest to release her from any kind of liability or future causes of action.
Yeah, so I understand your point about Lily. Our position on that is, at the end of the day, she's still a professional and she does, have some accountability, but our client is also interested in releasing her and not pursuing, claims against her if we can reach a satisfactory agreement between Atrium and Bitner.
Okay. How do you feel about us coming to an agreement to release all future liability from Cochran if we can settle at 75?
Just a second, please. Okay, so just to clarify, $75,000 from the Bitners within 45 days after refinancing the amount of time that it would take to secure a loan would release Lily of all claims from both Bitners and Atrium.
The agreement we're contemplating would be, obviously, in exchange for the payment from the Bitners, the business between our two clients would be done, and we're also contemplating that the Bitners would release or agree not to pursue claims against Lily, and we would put the entire matter behind us at that price.
Okay. Just one more second.
Sure.
Okay, I think that's something that we can do.
Okay.
Okay, I think maybe the last thing we'll do is we can briefly get all of us together. We'll get Cochran in the room as well, and we'll just go over the draft of the agreement that we put up. Make sure that there are no issues, no final surprises, and that everyone's okay. And I think we will be able to put this behind us.
Okay, sounds great. Thank you so much.
Thank you, everybody, for joining us today. It seems like we've all come to an agreement. So how about we all just go through the terms that we've agreed upon and run through them, and then we'll the next steps from here will be to draft an agreement in a settled form.
Sounds good.
Sounds good. So what was kind of the nature of the agreement that y'all ended up on?
So the Bitners have agreed to pay Atrium a total sum in one payment of $75,000, and that's going to be through a refinancing loan, which will be secured by the Bitners in 45 days. So payment will be made to the Atriums in 45 days.
Okay, and just to be clear, your client is not holding my client liable for any further causes of action?
Correct. The Bitners have agreed to release Cochran from all claims.
Perfect.
So in light of the agreement we're doing, it seems like it makes the most sense to just do a standard compromise settlement agreement, and we'll just all of our clients will be named parties. And then a mutual release also seems like the best plan, since we plan to not go forward with anything based on this incident. Does that work for everyone else?
Yeah, that does sound great.
Yeah, that sounds good.
And just as far as our negotiation went, so the settlement agreement should have a clause in there about the Atrium's paying the attorney's fees for my client. Is that correct?
Yes, that's correct. We'll also, so not only is Atrium releasing Lily Cochran from all the liability and future possibility of lawsuit, but we're also going to be covering $1,000 in attorney fees.
Okay, that sounds great.
Awesome.
So we'll just draft some forms up and we'll send them around, and we have a signature page here we can use to make the e-signatures, and from there, if anyone has a problem, we can talk about it, but I think we can manage this from there.
Okay, sounds good. Thanks for meeting.
Thank you so
Thanks.
much.
It was a pleasure working with all of you.